What is the most bizarre legal case that you have ever heard? Did you hear the case of a man who sued God for negligence and cruel and inhumane treatment of humanity? Yes, it is a true case, and it shows that the annals of jurisprudence are filled with tales that are too strange to be true. In this video, we'll explore 10 of the most bizarre court cases that have captivated the public's imagination. Prepare to be amazed by the weirdest trials and tribulations the courts have ever seen. Number 1. The case of suing God for negligence. In 2008, Nebraska State Senator Ernie Chambers filed a highly unorthodox lawsuit against the Judeo-Christian God, arguing that the deity had exhibited negligence and cruel and inhuman treatment of humanity. Chambers contended that God had made threatening statements, caused destruction, and inspired natural disasters that brought suffering to the world. The lawsuit was Chambers' response to another case he deemed frivolous, intended to highlight the court system's willingness to entertain even the most unconventional claims when principles of justice and fairness were perceived to be at stake. However, the court ultimately dismissed the case, citing the practical difficulty of properly notifying an omniscient deity who lacked a fixed address. Chambers countered that God's omniscience meant the deity was aware of the lawsuit, but the court remained unconvinced. This unusual legal battle raised complex philosophical and theological questions, such as the age-old problem of evil and the concept of acts of God in the legal realm. While highly unorthodox, the case demonstrated the legal system's openness to entertaining even the most unorthodox claims when fundamental issues of justice were perceived to be at the heart of the matter. Number 2. The case of Aama worth $5 million. In 2018, a seemingly minor grammatical error in a Maine labor law statute led to a multi-million-dollar payout for truck drivers in the state. The law in question dealt with overtime pay exemptions and hinged on the placement of a single comma. The statute listed a series of activities that were exempt from overtime requirements, including the canning, processing, preserving, freezing, drying, marketing, storing, packing for shipment, or distribution of agricultural products. The absence of a comma after the word shipment created ambiguity about whether distribution was intended to be a separate exempt category. Truck drivers, represented by the Oakhurst Dairy Company, argued that the lack of a comma meant the exemption applied only to the packing for shipment, not the distribution of goods. This seemingly minor grammatical distinction ultimately cost the company $5 million in back pay and damages. The case highlighted the critical importance of precise language and punctuation in legal drafting. It also cautioned lawmakers and businesses alike, underscoring the need to carefully review statutes and contractual language to avoid unintended and costly interpretations. The saga demonstrated how even the smallest typographical errors can have significant real-world implications. Number 3. The case of affluenza defense. In 2013, 16-year-old Ethan Couch was involved in a drunk driving accident in Texas that claimed the lives of 4 people. Couch's defense team put forth an unusual argument, stating that the teen suffered from affluenza. Affluenza, a purported psychological condition in which his privileged upbringing had prevented him from developing a proper sense of responsibility and accountability. The affluenza defense sparked outrage, with many criticizing it as an attempt to excuse wealthy, entitled behavior. Nonetheless, the judge found the argument compelling and sentenced Couch to merely 10 years of probation rather than the 20-year prison sentence prosecutors had sought. The lenient sentence provoked widespread public outcry. Many argued that Couch had effectively received preferential treatment due to his family's wealth and status. Critics contended that the affluenza defense set a dangerous precedent, essentially allowing the wealthy to avoid the consequences of their actions. The Couch case reignited debates about systemic inequities in the criminal justice system and the role of personal responsibility, particularly for young offenders from privileged backgrounds. It highlighted the perceived double standard that often allows the wealthy and well-connected to avoid harsh punishments, even for serious crimes. The fallout from the controversial affluenza defense would linger for years to come. Number 4. The case of Twinkie defense. In 1979, former San Francisco supervisor Dan White faced trial for the killings of Mayor George Moscone and Supervisor Harvey Milk. White's attorneys put forth a novel and highly controversial legal defense, the Twinkie defense. The crux of the argument was that White's consumption of sugary foods, including Twinkies and other snack cakes, had caused his blood sugar to plummet. This led to a diminished mental state at the time of the murders. White's lawyers contended that this sudden blood sugar drop had impaired his ability to form the requisite intent for a first-degree murder conviction. The scientific basis of the Twinkie defense was widely questioned, but the jury found it persuasive enough to convict White of the lesser charge of voluntary manslaughter. The lenient sentence, which included only around 5 years in prison, sparked outrage from LGBTQ+ advocates and the broader public. The Twinkie defense quickly became infamous as an example of creative, if questionable, legal strategies used to secure more favorable outcomes for wealthy or privileged defendants. It highlighted the perceived inequities in the criminal justice system and the lengths to which some will go to avoid the most serious consequences for their actions. Number 5. The case of the frozen embryos. In the 1980s, a high-profile legal battle erupted in California over the fate of a divorced couple's frozen embryos. The case, known as the case of the frozen embryos, would go on to set important legal precedents regarding the status of embryos and the rights of individuals involved in vitro fertilization. The dispute began when Noel and Mary Sue Bickerton divorced, with the couple disagreeing over what should happen to the several frozen embryos they had created during their marriage. Mary Sue wanted to use the embryos to have more children, while Noel sought to have them destroyed. The case made its way through the courts, with judges grappling with complex questions about the legal and ethical status of embryos. Was an embryo a person deserving of legal protection, or simply a collection of cells? What rights did each partner have over the embryos they had created together? Ultimately, the California Supreme Court ruled in Noel's favor, determining that he had the right to prevent the embryos from being implanted. The decision established that embryos were not equivalent to persons, and that individuals had the right to make decisions about the disposition of their frozen embryos, even after a divorce. The case's far-reaching implications continue to shape legal and ethical debates around reproductive technologies and the status of human embryos. Number 6. The case of the stolen kidney. In 2004, a shocking medical malpractice case unfolded in Israel, known as the case of the stolen kidney. The incident began when a man underwent a routine surgery, only to wake up and discover that one of his kidneys had been secretly removed and transplanted into his cousin, who was suffering from kidney failure. The victim immediately filed a lawsuit against his cousin, alleging that the kidney had been taken without his knowledge or consent. The case made its way through the Israeli legal system, eventually reaching the country's Supreme Court. After carefully examining the evidence, the Supreme Court ruled in favor of the plaintiff, ordering the cousin to pay $270,000 in compensation. The court determined that the unauthorized removal and transplantation of the kidney constituted a grievous violation of the victim's bodily autonomy and right to make decisions about his own medical care. The landmark ruling sent shockwaves through the medical community, underscoring the critical importance of informed consent and the need to uphold rigorous ethical standards in organ transplantation procedures. The case also highlighted the vulnerability of patients and the power imbalance that can exist between doctors, patients, and their family members. The case of the stolen kidney has since been widely studied and discussed. It is a cautionary tale about the ethical pitfalls that can arise in the high-stakes world of organ transplantation. Number 7. The case of the stolen violin. In 2010, the classical music world was rocked by the theft of a priceless Stradivarius violin belonging to renowned violinist Roman Totenberg. The exquisite instrument, crafted by the legendary Italian luthier Antonio Stradivari, was worth an estimated $3 to $5 million. Totenberg, a beloved figure in the classical music community, was devastated by the loss of his beloved violin, which he had played for decades. Despite an intensive investigation, the crime remained unsolved for over 35 years, leaving Totenberg and his family with little hope of ever recovering the cherished instrument. That is until 2015, when Totenberg's daughter, Nina, happened to spot the missing Stradivarius at an auction house in New York City. After careful authentication, the violin was confirmed to be the one stolen from her father all those years ago. The recovery of the Stradivarius was a remarkable triumph, not only for the Totenberg family, but for the broader classical music world. The case had captivated audiences for decades, and its resolution was a testament to the perseverance and determination of those who refused to give up on finding the stolen masterpiece. This case is a poignant reminder of the cultural and historical significance of the world's finest musical instruments and the length to which individuals will go to preserve and protect them. Number 8. Pigs charged in France. In the 16th century, a peculiar legal phenomenon took hold in parts of France: the formal trial of pigs and other animals accused of committing crimes. These so-called animal trials were a bizarre yet surprisingly common practice during this period. The trials would begin with the animal being formally charged and arraigned, just as a human defendant would be. Prosecutors would present evidence of the animal's alleged wrongdoing, ranging from crop destruction to attacks on humans. Lawyers would then be appointed to argue the animal's defense. In many cases, the trials would result in the animal being found guilty and sentenced to death, often through public execution. The rationale behind these trials was that animals, as God's creations, had a moral obligation to behave in accordance with divine law. Their failure to do so was seen as a violation that required judicial punishment. While the concept of putting pigs on trial may seem absurd to modern eyes, these cases highlight the legal and theological complexities of the era. They reflect a time when the line between human and animal was not always clearly defined, and when the natural world was believed to be subject to the same moral and legal codes as humanity. This phenomenon reminds us of the evolving relationship between humans and the natural world and the changing role of the law in mediating those interactions. Number 9. The case of monkey selfie. In 2011, a remarkable and unprecedented event occurred in the world of photography. A macaque monkey named Naruto took a selfie using a camera belonging to British wildlife photographer David Slater. This unique image sparked a legal battle that became known as the monkey selfie case. Slater claimed that he held the copyright to the image. This was because he was the owner of the camera and the one who had set up the situation that led to Naruto's spontaneous photograph. However, animal rights activists, led by the organization People for the Ethical Treatment of Animals, PETA, argued that Naruto, as the creator of the photograph, should be recognized as the rightful owner of the copyright. The case raised complex questions about the scope of copyright law and the legal status of non-human animals. Could a monkey be considered the author of a creative work and thus hold the rights to it? Or did Slater's role in facilitating the photograph mean that he was the true owner of the image? After years of legal wrangling, the case was ultimately settled out of court, with Slater agreeing to donate 25% of any future revenue from the monkey selfie to charities that protect the habitats of crested macaques. This case left a lasting impact, sparking ongoing debates about the intersection of technology, creativity, and animal rights. Number 10. The case of McDonald's hot coffee. In 1992, a seemingly mundane incident at a McDonald's restaurant in Albuquerque, New Mexico, evolved into a high-profile legal battle. It would go on to shape discussions around product liability and personal responsibility. The case began when 79-year-old Stella Liebeck purchased a cup of coffee from a McDonald's drive-thru and spilled it on herself, resulting in severe third-degree burns that required hospitalization and skin grafts. Liebeck subsequently filed a lawsuit against McDonald's, alleging that the coffee was served at an excessively high temperature and that the company was responsible for her injuries. To the surprise of many, Liebeck was awarded a substantial settlement of $2.9 million, which ignited a firestorm of public debate. Critics argued that the verdict was a prime example of the so-called lawsuit culture, where individuals sought to exploit the legal system and place blame on companies for their own negligence. However, proponents of Liebeck's case emphasized that McDonald's had known about the dangerously high temperature of their coffee for years. Furthermore, the company's prioritization of profits over customer safety was the root cause of the incident. This case became a touchstone in discussions about tort reform, product liability, and the balance between individual responsibility and corporate accountability. Its lasting impact continues to shape the legal landscape and our understanding of consumer rights. To wrap up, these bizarre court cases show that truth really can be stranger than fiction in the legal world. From suing God to million-dollar commas, the courtroom has seen it all. We hope you enjoyed this journey through some of the weirdest trials in history. If you want to stay updated on more fascinating legal oddities and intriguing stories, don't forget to hit that subscribe button and turn on notifications. Thanks for watching, and we'll see you in the next video.